My name is Daniel Panstrom, and I'm the current faculty director of the Rappaport Center for Law and Public Policy here at Boston College Law School. And on behalf of myself and our executive director, Lissy Medvedar, and our assistant, Abby Chingo, who was just here, but oh, there she is. It's my pleasure to welcome you here. One of the center's main purposes is to bring together policymakers and thought leaders to engage in dynamic discussions on critical public policy issues. These discussions, forums, conferences, and symposia regularly involve speakers from various levels of government, judges, business leaders, academics, members of NGOs, activists, etc. Today's program on progressive prosecution connects with many of our previous events, in particular Monday's excellent community address to a packed house in this room by our current senior fellow, former San Francisco District Attorney Chesa Boudin. It also connects with much of last year's programming led by our distinguished visiting professor, Jeffrey Robinson, which focused broadly on many issues of systemic and structural racism in U.S. law and society, and in one program specifically on peremptory challenges in jury trials. So please do check our website for upcoming programs, of which I will just briefly mention two. One is on Thursday, February 7th at 11:45. We'll have a timely and critically important discussion about affirmative action, where we've been and where we are going. And in deference to Jeffrey Robinson's wonderful documentary, Who We Are, one might also ask, whom do we mean by we? In a related, more specific and more Boston-focused vein, on Wednesday, February 15th, also at 11:45, we'll have a panel discussion about admissions practices and the general state of the so-called exam schools in Boston. So please do stay tuned, check our website. You are all invited to all of our events, and most of them have food of good quality. Today's program is entitled The Future of Progressive Prosecution. One could hardly think of a more important or compelling topic in light of tragic recent events in Memphis, in California, and sadly across the country for many, many years. But our title was deliberately chosen to be at least tacitly optimistic. We think there is a future for progressive prosecution, but we have to think hard about what that future is. Indeed, the very term progressive prosecution is fraught and complex. Critics on the left, including many so-called abolitionists and critical race scholars, often argue that the whole system needs to be deconstructed, torn down, and rebuilt on totally different foundations. On the right, one hears reports of rising crime rates in out-of-control cities, much of the responsibility for which is laid at the feet of progressive and other prosecutors and their allies. Is there a legitimate, pragmatic, progressive middle ground here? To help us navigate these complex and charged waters, we're lucky to have a fantastic panel and just the right person here at BC to lead today's discussion. Professor Mike Cassidy teaches and writes in the areas of criminal law, evidence, and professional responsibility. He served as chief of the Criminal Bureau in the Massachusetts Attorney General's office under Attorney General Scott Harshbarger. He also was the founding faculty director of the Rappaport Center for Law and Public Policy. Mike is a leading expert on prosecutorial ethics and provides national training to public sector attorneys. In 2021, he was appointed by the Supreme Judicial Court to a 4-year term on the Board of Bar Overseers. He also served on the State Ethics Commission, the Judicial Nominating Commission, the Governor's Commission on Corrections Reform, the Advisory Commission on Evidence Law, and the Standing Committee on the Rules of Professional Conduct. He's been an advisor to the National District Attorneys Association and a legal consultant to the Department of Justice, the U.S. Department of Justice, on issues of police misconduct and prosecutorial ethics. In 2012, he was elected to the American Law Institute. Mike has published in many top law reviews and is the author and co-author of 3 case books in the field of legal ethics. So we are in very good hands, to which I now turn us over.
Thank you, Dan, and thank you to everybody for coming today. I know we're going to have lots of questions. I have questions of our panelists. So the way I'm going to break down today's proceedings is I'm going to ask some questions first, and then hopefully save at least a half an hour for questions at the end from the audience, both here and remotely, because we are broadcasting this panel. I'll start with introductions. To my immediate left is our current district attorney in Suffolk County, which includes the city of Boston, Kevin Hayden. Kevin was appointed to this office when Rachel Rollins was appointed U.S. attorney in Boston. He was appointed by Governor Baker, and he won his first election, his first full term in November. So he has a wealth of experience as a prosecutor and a criminal defense attorney prior to taking the job as Suffolk County District Attorney. He started his career in the district attorney's office as a gang prosecutor. He was chief of the Safe Neighborhood Initiative, which is an initiative jointly staffed and funded by the Attorney General's office, the district attorney's office, and the Department of Justice here in Boston. He left the office to pursue a career as a criminal defense attorney, and then came back to public service, where he served as chair of the Sex Offender Registry Board. Next to Kevin on his left is Donna Patalano. Donna is a BC Law graduate, class of 2001. She is an expert in wrongful conviction. She founded the first conviction integrity unit in the state of Massachusetts. She lectures and goes to conferences nationally on this topic. She also has experience both as a prosecutor and a criminal defense attorney. She has been an appointed public defender doing appeals, appointed by CPCS on major felony cases. She also served as head of training and ethics in the Suffolk County District Attorney's Office under Dan Connolly, and then under Rachel Rollins, she served as the general counsel to the entire office, including leading their conviction integrity initiatives. And then to Donna's left is Chesa Boudin, who, as Dan mentioned, is our Rappaport senior fellow in residence this week. Some of you have already gotten a chance to meet Chesa and hear his talk or meet with him in small groups. He's making the rounds to classes, and we're very, very grateful that he's here with us this week. Chesa went to Yale University and Yale Law School. He clerked for federal judges and then served as a public defender before running for and winning the office of San Francisco District Attorney in 2020, and he served until 2022 when he was recalled by the voters of San Francisco, a matter that I'm sure we'll get into today. So what I love about this panel is they are all have extensive careers in public service, but they've also seen the other side of the law. All three of these people have also served as criminal defense attorneys. So our goal today is really to focus on what is a progressive prosecutor, and given recent events, what does that mean for the future of progressive prosecutions in America? I just want to start by one recent study from the Pew Center. Just 3 months ago, the Pew Center did a poll and found that violent crime, a concern about public safety in the congressional elections, was on top of voters' minds, behind only the economy. It was the economy, and then gun violence, and then violent crime. And of course, gun violence and violent crime overlap. So if you combine those two ratios, I would say public safety is the top of voters' minds these days. And some people are drawing a correlation between certain progressive prosecution policies in some districts and rising crime rates. In many large urban cities, in the last 2 years, crime rates have risen 9%, violent crimes. Not every city, but if you look at cities of over 500,000 people and take the average, it's 9%. And particular cities have been having problems. Atlanta, Baltimore, Milwaukee, Los Angeles. Okay, and the rise of gun violence by juveniles is also steadily increasing. So some people are drawing correlation between liberal criminal justice policies and rising crime rates, whether those correlations are warranted or not. And so what we want to talk about today is, what does it mean to be a progressive prosecutor, and how do we sell that to the public in a way that gets public support? So what I want to do, just to start out with a definitional question, and I'll start with District Attorney Hayden. I'd just like each of our panelists to comment for no more than 2 to 3 minutes about what they think the central tenets are of progressive prosecution. And we'll go down the row, and if somebody before you says something you agree with, no need to agree with it. Just add to their list of what you think the central tenets of progressive prosecution are, and what modern prosecutors should be doing in terms of their priorities in office. Let's start with District Attorney Hayden.
Thank you. I'm gonna try to do this in 2 minutes to the best of my ability. You know, a couple years ago here in the Massachusetts area, there was actually a public service campaign, if you will, and it's titled my good friend Masad Hall sort of led the way on. It was called "What a Difference a DA Makes," right? And I think that question really gets right to the heart of what progressive prosecution is about and what it should be about. Is progressive prosecutors really understanding the role that they play, the differences they can make, the power and the influence that they actually do yield in a system that may not be always a level playing field. Having been a defense attorney, having been a prosecutor myself, I can tell you, I know firsthand that you might think that playing field is always level, but quite frankly, oftentimes it's not. And so therefore, as prosecutors looking at what are the alternatives and ways to make a difference in our criminal legal system beyond just prosecuting in the courtroom, beyond just charging people with crimes and then going through the motions and the motions to suppress and all the rules of criminal procedure and then determining the sentence. The role of prosecutor is so much more than that. I'll circle back to sort of what I think that means in a second, but I can also tell you that this is the reason why I do what I do and why I started in this job is because as a Black man, how our criminal legal system is affecting us has always been vitally important to me, and really at the heart of everything I do. And I'm going to give, God rest his soul, I'm going to read it because I don't want to mince his words. Chief Justice Gantz, in speaking at a state judiciary address back in 2016, and many of you may have heard this quote before. It's really short. And he talked about racial disparities within our criminal legal system. And he said and declared, we need to learn the truth behind this troubling disparity. And once we learn it, we need the courage and commitment to handle the truth. Right? So for me, that is a major part of what real progressive prosecution is all about. There is not a shadow of a doubt about racial inequities and injustice that's happening in our criminal justice system. And if we don't have the courage and the integrity and the ability to handle that truth, and I think when he said that, he meant really handle it, like not just acknowledge it, but also do something about it, then we're really missing the boat. So for me, that lies at the core of progressive prosecution. But then going back generally to what I was talking about earlier in terms of what the power the DA has, I think real progressive prosecution has to address the entire diaspora of our criminal legal system. And that means that district attorneys are involved in intervention and prevention strategies before crime happens in the first place. They're involved in alternatives to prosecution when it gets to that point where prosecution is happening. Are there alternatives and should there be, and in what circumstances should those be deployed? And then on the back end, because there is prosecution, what happens to citizens that are returning back into the community? We call it reentry or returning citizens. What are we doing for returning citizens in terms of equipping them to come back out and be productive members of our society and have just an opportunity that they may not have had before? And I think that those are all things that a progressive prosecutor should be addressing and looking at. Thank you. Donna.
So first, thank you, Mike, Lizzie, Dan, it's thrilling to be here. My 1L section was just down the hall from here. I was the oldest student there and the only mother at the time, and so I'm thrilled to be there. And happy to be here pitch hitting for my old boss, Rachel Rollins. I'm sorry that she's not here. I know she would love to have been here. I stand in her stilettos only for a few minutes. There are different definitions of progressive prosecution. There's definitely not one size fits all. But having been general counsel for Rachel Rollins, I can tell you that in my experience, progressive prosecutors, they lead with a vision and intentionality and inclusivity. That's critical to the mission of a progressive prosecutor. A progressive prosecutor approaches public safety through a data-driven approach. That means empirical review of written policies to see what the impacts are of those policies on the communities and case trends. That data-driven review is critical to determining what succeeds and what doesn't. Let's look at that and make changes based on those empirical reviews. It means embracing transparency through all sorts of things, including public records, to make sure that you are attempting at least to rebuild trust with communities that have been over-policed and over-prosecuted. It means, a progressive prosecutor, she cares. She cares about the community. She cares about survivors. She cares about the accused. She cares about her staff. And she does that by embracing accountability, being accountable to all of those stakeholders, both externally and internally. I would say if I were to give a sort of a one-sentence definition of a progressive prosecutor, it would be a person who is a force of nature, who is brave, and who has a backbone of steel that is forged through her own life experiences. And that's how my experience of what a progressive prosecutor is.
I'm just going to put this out there. I don't think it's any coincidence that I'm all the way on the left of this table. No, really, thank you all at the Rappaport Center for organizing this, for bringing me here. I'm looking around the room and I'm seeing so many students who I've had a chance to speak with and meet with over the time I've been here and to learn with. So thank you for bringing us together and for giving us a chance to talk about these issues that obviously have defined all of our careers, at least, and hopefully will attract many of you also to careers in interest of justice. I have three answers to the question. The first is, I think progressive prosecutors have to be committed to a vision of justice that involves reducing reliance on incarceration, ending mass incarceration. That's first. Second, expanding services for survivors and victims of crime. And third, enforcing laws in ways that are equitable. That means also prosecuting billionaires or politicians or police officers, for example, when they commit crimes, not only prosecuting people who are poor and powerless, which is sadly the historic norm. I think that's really what it comes down to. And you can look at a lot of the other things. I agree with what my colleagues up here said. I think a lot of other areas of the job fit into those three categories. But at core, for me, that's the vision of the progressive prosecutor movement. I don't want to suggest that that's all prosecutors should be doing. But I think if we talk about this movement and the role that prosecutors have, I see it first and foremost as a harm reduction movement. How can we as prosecutors stop causing some of the harms that our offices and the institutions we partner with historically have been responsible for? And how can we empower those other agencies and social forces, as has been said, that are upstream from us to do work that makes our communities safer, stronger, and more vibrant?
Thank you, Chesa. My boss, Lizzie Medvedow, asked me to remind everybody that this is being recorded. So this is being recorded. I know that. District Attorney Hayden, you succeeded Rachel Rollins, who got a lot of publicity around the country for being one of the country's most progressive prosecutors. She was often mentioned alongside Larry Krasner in Philadelphia and Marilyn Mosby in Baltimore. She was given the job of United States Attorney in Boston. You were appointed to fill her shoes and then were elected to fill her shoes. And if the media is accurate, during the election, you kind of pulled back on a few of her policies in order to walk a slightly more centrist line. I was wondering if you could just tell our visitors today where and how you disagree with Rachel Rollins and what policies you've either cut back on and changed since she took office.
Sure. So first of all, I'd say I don't know if I necessarily agree with the media's perception. There were quite a few prosecutors who were in the office back when I was there before, were still there. And a number of them came to me and said, you know what? All of this now politically correct, progressive prosecution conversation that's going on. You were walking that talk and doing it back then in 1997, 98, 2000. And everyone looked at you like you were crazy. And so, you know, I don't know if there's anything that we really walked back. When it comes to the integrity review board, that good work continues. There's a number of decisions that were pending when we got there and took over that we've continued and completed, and others as well. One thing that I do believe, and I said it over and over again during the campaign, and continue to say that, and I don't think, and we have a transition committee team going on right now. We're looking exactly how we're going to use that data and statistics to really drive policy and really inform the public on where we are. But I don't believe in a formulaic approach to prosecution of cases. I don't believe that you can say, oh, you know, these cases can now or should not be prosecuted. And I would say, in fairness to everybody, and including the now U.S. attorney, I don't think she did either. Right? It was not a absolute when it came to what was prosecuted and what was not prosecuted. And so my belief at its core is that you've got to really look at each and every situation and make independent decisions. I think that's what prosecutors are hired to do. And some people will say, well, how do you do that? That's not fair. And how do you deal with the, you know, micro biases and that sort of thing? Well, that can seep in anytime, anywhere, whether you're using a percentage approach, said 25 will not be prosecuted, 75 will. No matter how you look at it, you're making decisions on a case-by-case basis. I think it's an important, tough job of prosecutors at every level to try to make those decisions, to always be looking to alternatives to prosecution when appropriate, but not to have any hard and fast rules around that.
Thank you. Donna, would you like to comment, having seen the inside of the office under Rachel Rollins and now being a criminal defense attorney? Do you agree with District Attorney Hayden that there aren't really any definitive policies that have been cut back on?
Well, I would say first, although I'm a defense attorney now, I'm conflicted from doing any cases in Suffolk County. By my own rule, it's not, so just to be clear on that. You know, I think actually, and I'm going to be an appellate nerd and a policy wonk right now, but I actually think hard and fast rules are important. And one of the things that, you know, I can address specifically is our declination policy. It's referred to commonly in the press as the list of 15, right? There were 15 low-level nonviolent misdemeanors. The presumption was non-prosecution. And that policy was 9 pages long. And we had 2 all-staff trainings with Venn diagrams and brown bag lunches to train the staff. If you're going to approach on a case-by-case basis, rather than looking at one case, the tree, you need to look at the whole forest. And you're going to look at the forest through the lens of this 9-page policy, which, by the way, 2 months after we initiated the policy, we changed. Because we had real data on the ground, we had experiences, we brought the supervisors in and we said, what's working, what isn't working. So the ability to have policies that are written, you can hold your staff accountable on it, the community can hold the office accountable on it. I think that is really important. I'm not sure that that's something that is as robust in DA Hayden's administration as it was under Rachel Rollins. And the other thing is that's near and dear to my heart is the Integrity Review Bureau. I will say Derek Kesselheim, who is the chief of the Integrity Review Bureau, is here, and a dear friend of mine. You know, during the first year of the IRB under Rachel Rollins, we reviewed 100 applications from individuals who said they were wrongfully convicted. We took those 100 applications and we ended up on 13 cases within the 2 years of the IRB under Rachel Rollins, reversing convictions, sometimes exonerations. I have a problem with that word that probably puts me to the right of you and to the left of you, but What I will say was those 13 cases resulted in 410 years that people served. 410 years stolen. And of those 13 people, 12 were Black men. It's got to say something to you. Those statistics are important. And I'm not saying that we should be doing everything through statistics, because you can also lie with statistics. But I can tell you that that was an important part of our approach that we really embraced.
Chesa, Boudin, I wanted to follow up on your question that progressive prosecutors should be willing to prosecute the billionaires and the corrupt public officials. Oftentimes when we talk about progressive prosecutors, or at least when the media does, it's in terms of what they're not going to do. They're not going to prosecute certain level offenses. They're not going to transfer juveniles for trial as adults. They're not going to ask for cash bail. What do you think defines a progressive prosecutor in terms of the types of cases that they should have the courage to do outside of the public corruption cases? Are there certain types of criminal offenses that modern prosecutors should be more willing to prosecute than their predecessors?
Absolutely. And, I think both things are true. If you envision, as I do, the progressive prosecuting movement as a harm reduction movement, then we need to do things like the Rachel Rollins memo that was described, where we need to be willing to say there are certain categories of cases we're not going to prosecute. This is an answer to your question. I know you're asking about what we're going to do affirmatively, because we have limited resources. And so we might, in a perfect world, say, sure, we'll prosecute every kind of crime the legislature can come up with. Maybe somebody would say that in a perfect world, but we don't have those resources. We don't have the courtrooms, we don't have the prosecutors, we don't have the investigators. And so we have to make difficult choices. And those choices are guided in part by the communities we represent, by the trends around crime and data. And also, I think at core, they need to be guided by principles and by values. And all of us in this room, in this law school, understand as a fundamental premise that this country was founded on the concept of equal protection under law. And if we're not giving life and meaning to that promise, etched in stone in courthouses across this country, then we're failing as prosecutors. To give meaning to equal protection under law requires that we affirmatively file cases and investigate and work up cases, including where the people who are being investigated, who are being prosecuted, are powerful. We cannot have a system of justice that depends on the color of your skin, on the amount of money you have in your bank account, or on how well connected you are in City Hall. But sadly, that is the system. And we have one system for all those powerful groups and a different system for everybody else. And we have to be not only aware of that, but we have to be proactive as prosecutors in trying to fix it. Not only to be progressive, but to earn and restore the integrity of the system that we want to call a system of justice.
District Attorney Hayden, would you like to comment on certain types of cases that you've instructed your staff to take more seriously than you think were done in the past?
No, only because I don't think that those cases and the cases that we look at in terms of alternative prosecution has really changed that much at all. So if you want, you talk about the list of 15 and those lower level offenses that you look at for not prosecuting and or alternative prosecution. That's the same list of cases that Ralph Martin used, same list of cases that Dan Conley used, same list of cases that now U.S. Attorney Rollins used, same list that I use. The question then obviously is, well, at what level are you making those decisions for alternative prosecution? At what level are you engaging in declination? So for me, it's not a question so much of which particular cases. I think that that's something that you need to look at in every case. But for me, it's more of a question of, are you offering, when you are offering alternatives to prosecution, are you offering real alternatives to prosecution? So one of the things that we're looking at right now is an emerging adult alternative prosecution program. We'll be meeting with Robert Kinshirf and others from MGH and Harvard tomorrow on this issue. to provide real alternatives to prosecution for our young adults that are coming into the system. Whether they should be in the system or not, if they're in the system, what are we doing, and are we offering them real alternatives to prosecution, similar to what we're doing with the juvenile alternative resolution program already in the office. So I think that is really the more important question that we need to be asking ourselves. In terms of in terms of data statistics, we need to always be mindful of those and look. So we'll see as we continue to do the work we do, and as we look at those data statistics, and we'll see where we are. Right. I actually just got off the phone with David Lewis earlier this morning, who's still with our integrity review board, about the fact that we're actually going to be looking at the data and statistics around where we've been since it started to really try to drive going forward. And he was frank with me that it's going to probably take a couple more months for us to really have that information, to really take a look at it. But we're constantly want to look at the data, at the statistics, at the reality of the results that we're achieving in order to try to drive the vehicle, so to speak, because we always want to be focused on, as I mentioned earlier, looking at those true racial disparities. We also always want to be looking at reducing our carceral footprint, which we have in Massachusetts. Our carceral footprint in Massachusetts is about maybe as low as it's ever been, certainly in quite a long time. And that's something that we want to continue to engage in.
Thank you. So I want to talk a little bit about what Donna mentioned in terms of transparency and that being a common value of progressive prosecutors. To the extent you all agree that transparency is a common value, I'm wondering whether you see the trade-off between transparency and deterrence, which is an important role the criminal law plays in terms of sending signals to others not to commit crimes. When progressive DAs say that they are never or rarely going to transfer a juvenile for trial as an adult, could that be leading to emboldened juveniles who are willing to possess knives and guns, and that contributing to the rise in juvenile violence? When progressive DAs say, I am not going to prosecute a first offense shoplifting case, could that be leading to the raid on stores and the businesses going out of business because they simply can't afford all the shoplifting that's going on in major cities like San Francisco and Chicago? And how do we balance this tension between transparency and deterrence? Is it a good idea to say never? Is it a better idea to say, I do not like transferring juveniles for trial as an adult, and I will only do it in the most extreme cases? Let's start with Donna Patalano, since she was focused on transparency.
Raise my hand and say, I want to talk about that. Transparency is really hard work. I mean, it's very hard work. Within the first month of Rachel's administration, she opened up all the data to academics. And 17 years, 65,000 cases. And she actually, I was in the room when she said, tell me if it works. Tell me if the list of 15, a presumption of non-prosecution for these low-level nonviolent misdemeanors, does it work? If it doesn't work, we got to figure out what does work. And so the National Bureau of Economic Research came back and they said, you know what, it's true. Under Ralph Martin and Dan Connolly, these lists of 50% of them were not prosecuted. So we were already on the right track. But once we had a written policy in place, it turned out that that number went up to 77%. So why is that important in non-prosecution? Well, when they looked at those offenders who were tried to find out if it was not prosecuted compared to similarly situated individuals, what was the recidivism? What percentage of people didn't come back? So if they were not tried, it was 45% of them did not come back and ever commit a misdemeanor again. All right. More importantly, almost 75% never committed a felony crime. I mean, it's a no-brainer not to do this, right? And how that leads to public safety. It saves taxpayers money too, right? So if you want to be a fiscal conservative, this is a policy that actually works.
Of course, that statistic only shows that those people didn't come back and commit another crime. It doesn't show that other people didn't commit those crimes.
Well, you know, as Chesa said, there are so many different factors in the, you know, it's certainly multifactorial, and unfortunately, the criminal legal system has become the final safety net, probably with emergency departments. the final safety net for folks who are caught up in food insecurity, housing insecurity, substance use disorders. So it's not, you know, the list of 15 or the presumption of non-prosecution for low-level misdemeanors is definitely not the answer to it all, but it certainly is a step in the right direction. And the difference between, you know, hoping, you know, and training your people to do something and training them under an explicit and intentional rubric is measurable.
Chesa?
Yeah, I just want to push back a little bit on the premise of the question on two grounds. You know, the first one is that, you know, if this correlation that you described were real, then surely in the 2.5 years I was district attorney in San Francisco, crime would have gone up, right? Because here I am all the way on the left end of the table. But actually, we saw a 20% decline in crime during my 2.5 years, as compared with 2.5 years prior to my administration. And secondly, surely if it was just about tone and messaging and transparency, the new DA who came in to replace me, DA Brooke Jenkins, who has said really intentionally and explicitly and repeatedly, and been all over the news, saying it's about tone from the top. We're going to talk tough, and that's going to change the way people behave. It's going to deter people from committing crimes. And why is it that crime is up 14% during her administration compared with my 2.5 years? Tell me that. Deterrence is real, and it's one of the real theories that you all will study in your criminal law class. But it doesn't just have to do with the severity of the punishment or the prosecution rates. In fact, if you look at Bureau of Justice research, the single most important thing when it comes to deterrence being effective has nothing to do with district attorneys or our policies or our communication. It has to do with certainty of arrest. If people who commit shoplifting in San Francisco or Boston or anywhere in between know that they're going to get arrested, they're far less likely to commit that crime, regardless of who the district attorney is or what his or her policies are. But in San Francisco, for example, if you commit a shoplifting crime and it gets reported, which we know most don't, there's a 99% chance you don't get arrested. Doesn't matter who the DA is. You could have Satan himself prosecuting each crime. If 99% of them don't get arrested, deterrence simply doesn't work. So that means we need to think holistically, we need to think system-wide, we need to think upstream, not just how do we prevent, but even if we're just focused on police and prosecution as a primary response, which I don't think we should be for many of these crimes, we need to think big picture. And if police don't have the resources to respond quickly enough or to make arrests in every instance of shoplifting, let's think about what's going on. Do we need more police resources, or should we use limited police resources to work our way upstream and dismantle the networks that are moving literally billions of dollars of stolen goods, mostly on eBay and Amazon, and we're all buying it, whether we know it or not.
So let's talk a little bit about the certainty of arrest approach. It reminds me of a policy that several of us who are old enough to have been around a while lived through in the 80s and 90s. The broken windows theory of policing. Let's saturate high crime neighborhoods with police officers who are going to take account of low-level crimes in those neighborhoods and help make those neighborhoods safe for the people who live there. PS, who are often brown and black and minorities. And let's let them not be fearful of going out of their house. That broken windows strategy really focused on low-level offenses. Why isn't that a central tenet of progressive prosecutors today? Who wants to focus on that?
Well, first of all, because there's lots and lots of empirical research that it doesn't work. Second of all, because personally, when I was district attorney, my priority was murders, sex offenses, gun violence. The more serious the harm, the more serious the consequences for the defendant and for the victim, the more resources I wanted to focus on it. Why? First of all, because we've got real people and real lives that are being destroyed by these crimes every day, and those need to be our priority. Second of all, because the consequences for the people we accuse are the highest, and we have an obligation as representatives of all the people, including the people we're prosecuting, to ensure procedural justice and fair outcomes. People aren't going to go to law school if they think the system is rigged. They're not going to become criminal lawyers if they don't have faith in the integrity of the outcome of our convictions. That's why it's so important to do the conviction integrity work. That's why we need to make sure that if we're prosecuting somebody for murder, they actually committed the murder that we're accusing them of. We can't cut corners with those cases in favor of shoplifting or graffiti. That's the main reason for me. But the other reason is that I think, again, going back to harm reduction, prosecutors do not have the tools to solve or to lock our way up out of poverty. And so many of those low-level crimes, so many of the ones in the Rachel Rollins memo described, so many of the ones that Fox News got angry at me for not making a higher priority. Illegal camping, trespassing, loitering, crimes that, by the way, have deep histories rooted in Jim Crow black codes. The racial and class history is, you don't need to read Michelle Alexander, though you should, to know where these laws come from.
I'm sorry.
Well, no, just, I mean, it was the last point. So I think if we recognize that many of the things that are real problems for small business owners, for homeowners, for the communities that we serve are rooted in poverty and social inequity, then we can solve them in ways that are more humane, more cost-effective, more fiscally conservative, and ultimately free up our limited resources and police department limited resources to focus on crimes that we're uniquely positioned to address, like gun violence, like sexual crimes.
But you say we're uniquely positioned to address, and in San Francisco, gun violence did go down during your term, but nationwide it has gone up. So something's not working. DA Hayden, do you want to comment on broken windows strategy, or do you agree with Chesa? Do you have anything to add?
I mean, I think we all agree that prosecutorial resources we never have enough prosecutorial resources to do the job that we need to do. That's an unfortunate reality. And as a result, we of course need to be focused on those more serious offenses. That triaging constantly happens, and the important part of that triaging is paying attention to the serious and the violent crimes. Those are the ones that need to be prosecuted and where people need to be held accountable. And so those lower level offenses need to be considered for alternative prosecutions or not being prosecuted at all. I came up under the Safe Neighborhood Initiative. I was the chief of the Safe Neighborhood Initiative. One might argue that was born out of the broken windows theory. I don't know. For me, I don't know. Never seemed like that to me. For me, it was much more about working together with your communities to understand what's going on in the communities and how to address the issues that are going on in those communities, and engaging with the community partners to work on real comprehensive intervention and prevention strategies, to work with the community on real tangible community policing and community prosecution. And that takes a lot of intensive and important work. I mean, we talk about transparency and being data driven, and that's an important part of transparency that needs to happen and that should happen and that will happen. But there's another aspect of transparency that goes deeper, and that goes deeper from really engaging with your community to having those meetings with them after hours as a prosecutor, as a police department, over cold pizza and stale soda, to look at the real issues that are at play and to really understand for the community what matters to them and what needs to be addressed and focused on. And for me, that's what it was always about. And I think what in our office it will continue to be about. I think that's a much more important emphasis than just prosecuting low-level offenses. We know that doesn't work.
I'd like to switch and talk a little bit about the rhetoric of progressive prosecutors and how that has maybe backfired in some respects, or at least influenced the Fox News cycle. Chesa Boudin was recalled in San Francisco. Larry Krasner has been impeached and is waiting trial in the Senate in Philadelphia. Marilyn Mosby is under indictment in Baltimore. Andrew Warren was taken out of office by the governor in Florida. Something is not clicking with the electorate here. And I would say it's safe to say that if progressive prosecutions won't play in San Francisco, why would they play in Des Moines, or why would they play in Oklahoma City? And so what I want to ask is, first of all, do you agree with that? I'm seeing Chesa Boudin shaking his head, so he does, and we'll get to it in a second. But if you agree with that, even in the slightest, is there a way we can change the rhetoric of progressive prosecutions while still accomplishing its main goals? For example, oftentimes I see progressive prosecutors in the media talking in extremes. We're going to eliminate cash bail. Well, really, there aren't any states in the country that have eliminated cash bail. New Jersey has gone the furthest. but it still has a presumption of pretrial release for gun offenses. And there are certain circumstances, certain high-level felonies where you can ask for cash bail. So choosing extreme words like eliminate, does that really help the progressive prosecution movement? I'm going to start with Donna Patalano. Donna ran against an incumbent DA in 2018. DAs have the highest incumbency rate, re-election rate of any statewide office in the country. Generally, DAs are not voted out of office. Donna ran on a progressive prosecution platform. She got 47.5% of the vote against an incumbent DA in Middlesex County as a first-time candidate, which was absolutely remarkable. I want to applaud you for that. But still, you lost in one of the most. I live in Cambridge. You still lost in one of the most progressive parts of Massachusetts. So what I want to talk about is there any way you all think we can change the rhetoric around this discussion to help the movement?
So first, maybe I should have got those facts from Mike before I ran for office. I didn't realize that. Maybe it was ignorance is sometimes bliss, I guess. But it was a remarkable experience. And the day after the primary, the first call I got was from Rachel Rollins, who said, Middlesex loss is Suffolk's game. Please come help me figure out. She had never worked in the Suffolk County DA's office before and knew I had deep relationships in the office. And I'm very grateful that she did that and thankful that we continue this kind of work. You know, there are a couple of things. One is communications are critical. And that meant for us, quarterly town hall meetings. Let me tell you, those are painful. When you're in front of the community, we always had a theme to the town hall meeting. We went to every corner of Suffolk County with those town hall meetings. Staffers came and we answered questions. There was always a front page news story after those town hall meetings because we were there answering questions from the people who were being impacted by our policies and by crime in the community. It wasn't just the communication to the community, but it was communication to our law enforcement partners. So when we had policies, when we expanded our Brady list for, I think, Woods Law School, so I don't really need to explain what a Brady list is, but when we expanded the Brady list, we met with the leadership of each law enforcement agency in Suffolk County. We met with the union, but not just the union for the supervisors, the union for the rank and order. And I will tell you, they didn't like what we were saying. They didn't like us, but they respected us, I believe, because we were willing to be in the room and talk to them about why we were doing what we were doing. And that was important to implementing the policy. And the final bit of communication was to our staff internally, which meant weekly supervisors meeting, quarterly town meetings with our staff. And whenever something happened, George Floyd, or some tragedy happened, and there are sadly too many of them, we met with our staff just to check in. Are you okay? This is what it means to us as leaders in this office. What can we do to help you? We brought in authors to speak about trauma-informed prosecution and how that made a difference. So those communications, I'm not sure we will ever get past, at least in the immediate, the Fox News knee-jerk, simple, do not prosecute kind of headlines. It just isn't that. It never was. It was a very detailed policy approach. Again, being that policy wonk, I guess. So the communication is probably to me the number one.
But if we can never get past that Fox News approach, how do we get more progressive prosecutors elected? Chesa, I can tell you've been chomping at the bit to come here.
Yeah, I got a few thoughts on this. I mean, I think it's a really important question. I appreciate you raising it. I totally agree. I think with one part of the premise of your question with what Donna was saying, I think communication is a huge issue. I think it's a challenge, not just for the progressive prosecutor movement, but I think it's a challenge for the Democratic Party and for progressives in this country in general. And it's one that I think we need to be more creative and we need to dedicate more brain power to, because I agree with you that we're falling short in a lot of ways on that. Where I disagree respectfully is I don't think the word eliminate, for example, is an extreme word. I don't think it's extreme to say. In fact, I'm pretty certain that everybody in this room agrees we should try hard as we can to eliminate racism. We should try hard to eliminate the role of wealth inequality in the outcomes of our justice system. That we should try to eliminate police brutality. I mean, I think we should try to eliminate wrongful convictions. And yes, we should eliminate money bail. And we should eliminate money bail for a very simple reason. We're not saying we should eliminate pretrial detention necessarily. We're saying we should eliminate the role of wealth in determining whether someone who's presumed innocent is in a jail cell or free with their families. That's not controversial. It's entirely consistent with the Due Process Clause and the Equal Protection Clause of the U.S. Constitution, and every court that seriously considered the issue has said as much. We should not eliminate, in my view, pretrial detention. There are people who we have accused of serious crimes, we have reason to believe will flee or will commit more serious crimes if they're released. And we should ask the court to hold them pre-trial without bail. Because if they're rich enough, like the officers who killed Tyree Nichols, to buy their freedom, that doesn't make us more safe. And it doesn't make us more just as a society. So I think, to me, that's a fundamental issue when it comes to the integrity of our justice system. You mentioned a couple of examples that I also want to just take a moment to reflect on. You mentioned Andrew Warren in Florida, you mentioned Larry Krasner in Philadelphia, you mentioned my own defeat. So I want to just take a moment because I think there's this narrative. And certainly on my election night, the news media from coast to coast was really quick to say, this is a major setback for the progressive prosecutor movement. And there's a lot of people in the movement who probably felt that way. I like to think so anyway. Don't disabuse me of that notion. But I think it's actually a false narrative. And I think it's a false narrative for reasons I want to just take a moment. I'm asking your patience to explain. I'm going to take apart each of those three examples, which are the most common high profile ones. And I'm going to talk about some that weren't mentioned in that example and don't get press coverage that they deserve. So first of all, let's start with the easiest. Andrew Warren's removal from office has nothing to do with the will of the people. He was elected twice to office in Florida. And the governor, Ron DeSantis, enough said, but anyway, Ron DeSantis summarily removed him from office. It wasn't democratic. It may have been legal technically under the Florida Constitution, but it in no way reflects the will of the people who elected Andrew Warren to serve twice. It was done. Why? Because Andrew Warren signed a letter that I also signed, and more than 36 other elected prosecutors around the country signed, saying that they would not prosecute reproductive choices in the wake of the Supreme Court overturning Roe v. Wade. And because of that, Ron DeSantis removed him from office. We know the majority of Americans support women's right to choose their own reproductive futures. So Ron DeSantis' political decision to remove somebody who was actually in line with the majority of Americans and been elected twice to office is not a democratic move. It doesn't in any way reflect vulnerability or weakness of the progressive prosecutor movement. Quite the contrary. It's an example of the kind of procedural tricks that the far right wing is using because they can't beat us in head-to-head elections. Larry Krasner. Everybody said he was going to lose his reelection because of all these policies, because crime was out of control. And gun violence in Philadelphia was arguably out of control, certainly rising significantly under his administration. But he won with more than 2/3 of the vote, his reelection. More than 2/3 of the vote. So the barely Republican controlled state legislature, House, impeaches him. You know who that same House didn't impeach? A district attorney you've never heard of in a different county who's currently being prosecuted for rape while he was in office. And the Republican state legislature didn't think it was important enough to prosecute or impeach that district attorney. But Larry Krasner, in the week leading up to a midterm election in which, as you say, crime was on everybody's mind, decided it was appropriate to impeach him, knowing full well that the Democrat-controlled Senate was never actually going to remove him from office. And in fact, the court that looked at the impeachment already ruled that the impeachment process was improper and that they didn't have any actual legal grounds to have impeached him. Let's take the one that's closest to home, the last example you gave, San Francisco. I was elected in 2019 with 42% of the vote, including second and third choice votes, because we use ranked choice voting. That means that literally, if you exclude second and third choice votes, I had about 1/3 of the votes in a four-way race. But then with second and third choice, I got up to 42%, 85,000 votes that were cast ultimately for me. In the recall, I wasn't running against anybody. There was no opponent. This wasn't somebody having the courage to do what Donna did, where you challenge an incumbent. knowing or maybe blissfully ignorant about the odds historically of trying to oust an incumbent. The right wing in San Francisco knew they wouldn't oust me in a head-to-head election if they had to put forward their policies and their views and their candidate. And so instead they spent $10 million. By the way, recalls have no campaign contribution or expenditure limits in San Francisco, but head-to-head races of candidate committees have a $500 max contribution. So billionaires were able to give literally, one guy who's Mitch McConnell's biggest donor gave more than $700,000 himself to get me recalled. That's more than I spent to get elected in total. One guy gave that to the recall. And despite all that effort, despite all the fear mongering, the pandemic, despite all the attacks, I got more votes in 2022 than I did in 2019. We had 100,000 votes against the recall. We had 45% of the vote. So our movement is actually growing. And I don't think you need to rely on the electoral outcome in San Francisco to see that. Across the bay in the same electoral cycle where I was recalled, Pamela Price was elected as the district attorney of Alameda County. In that same electoral cycle, despite a $10 million expenditure by right-wing forces in Los Angeles County, they failed for the second time in a year to even get the signatures to qualify for the ballot or recall against the George Gascon. In that same electoral cycle, Sarah Fair George in Chittenden County, Burlington, Vermont, was reelected despite overwhelming opposition from the police union. And nobody covered this election. Nobody covered Sarah Fair George. Nobody covered when Steve Mulroy, the prosecutor that's now being celebrated nationally for having the courage to file homicide charges against those 5 officers who murdered Tyree Nichols, was elected ousting an incumbent, a Republican incumbent, a conservative Republican incumbent, a tough on crime, tough talking Republican incumbent. And thank goodness the voters in Memphis had the courage and the foresight to elect somebody like Mulroy. Our movement is strong and it's growing. Join us.
Okay. I'm going to end with one last question and turn it over to the audience. And that's relationships with police departments, which can be very tricky for the progressive prosecutors. And Donna mentioned Brady lists. I just want to kind of unpack that a little bit. You have police officers who have troubling histories, disciplinary histories in their files, incidents of lying, incidents of criminal behavior, administrative sanctions in their disciplinary files. When do you have to turn that evidence over to the defense, and how do you even get it to turn it over? Some DAs are saying we're going to formulate do not call lists and tell our assistants not to prosecute a case where it depends on the testimony of one of these so-called bad cops. This, of course, has enraged police unions because it's labeling people bad cops. Other DAs have said, well, we're going to create a Brady list and just tell defense attorneys when there's Brady material on any of these police officers and encourage them to file subpoenas and then battle it out in court over whether the disciplinary file is revealed. I'm wondering, of the 3 of you, whether you think one approach is better than others for progressive prosecutors, and how that might strain police relationships in an era which we need to identify, where applications to police academies are way down. It's really hard to get qualified, exceptional people to be willing to be police officers these days. So why don't I start with you, District Attorney Hayden?
So I don't think do not call is a good idea. I mean, we've continued to maintain the rating list, if you will, in our office. And surprisingly to me, when I arrived, there's some other district attorney's offices in Commonwealth that don't have such a list. That was surprising to me. So we continue in that, and I think the notion of providing that information to the defense in the case is the right way to go.
Mr. Boudin, you want to comment on that?
Yeah, and I appreciate you raising this. I think it's such a difficult issue, and it's such an important one because, as you point out, prosecutors, whatever their politics, progressive or traditional, whatever it is, we rely on police as our key partners in 99% of the cases that we file. There are key witnesses. We have to be able to trust them, and we need our juries to trust them as well. By the same token, because of limited resources, because of our commitment to justice, we have to take measures to ensure we're protecting the rights of the accused. We need to make sure that our convictions don't get reversed. And if we're violating our obligations under Brady, then convictions get reversed. then the public loses trust in the system. Then we've got wrongful convictions that need to go back and be corrected. And one of the problems, and I'm gonna be a little technical here, but we're in a law school, so I think some of your professors might thank me. You know, there's a difference between constructive possession and actual possession. But under the law, we as prosecutors, we're obligated. We are treated as though we are in possession of everything that the police departments or other investigating agencies have, but we may not be in actual possession of that material. And this presents a real challenge. Let me just make it concrete. Let's say that there's a police officer, hypothetically, who did a traffic stop and shot the person he stopped and then lied about it in his police report. It might have happened somewhere once. Let's say that happens in San Francisco. And let's say that the police department doesn't tell me as the district attorney about that history, about that police report. Let's say there's no way I can know about it. And I'm relying on that officer and I'm calling him as a witness. And then the defense says, wait a second, I found a news report from 20 years ago where this officer did this shooting and it turns out he was lying and you didn't tell me. You violated Brady. It was never in my actual possession, but the courts don't care. It's constructive possession because it's my investigating agency. So we have to figure out a channel to make sure that our police departments are willing to work with our DA's offices and give us this material so we can fulfill our obligation. California law changed recently. California Supreme Court case, I want to say from 2014 or 15, somewhere around there, in which the Supreme Court of California basically says it's not the prosecution's obligation to give the material to the defense. The defense has equal access to it. They can file a motion just like the prosecution, but it is the prosecution's obligation to notify them that there may be Brady material. Now, one view, you could be overbroad. You could just say every police officer may have Brady material. Let's just provide the defense with a boilerplate notice in every case. That's going to waste judicial resources because then defense lawyers are going to be ethically obligated to file a Brady motion on every single officer in every case. Courts are going to have to review the personnel files. You get where I'm going. This is a mess of an area. And it puts at jeopardy the integrity of convictions, the bar cards of the prosecutors in our office who are trying to do the right thing, the morale of police departments because they don't like, all the finger pointing and the accusations. I think this is an area where courts have to do a much better job, where legislatures have to do a much better job, making clear what the obligations are, what constitutes Brady, how different parties can access it. And I think we need to do away with the legal fiction that everything in the police department's file is in our possession when we're in the district attorney's office, because that's just not how it works.
Thank you. Okay, I sense the audience is chomping at the bit with their own questions, so. Yes. And if your question is directed to a particular panelist, please identify the panelist.
Hello, my question is for Dean Hayden. I wanted to ask specifically about conviction integrity units. I know they sound good to voters, but the reality is quite different. And I know DA Rollins had a pretty substantial CIU. So I wanted to ask, and I know you're in talks with David Lewis and looking at statistics, but I want to hear about your general commitment to building up the CIU and continuing the work that DA Rollins has done, and generally reviewing convictions in that unit.
Sure. Our commitment remains absolutely the same, and we'll continue. I think it's a fundamental tenet of being a progressive prosecutor and of criminal legal reform. And so we're proud. I'm proud to continue in that work, and we will. And we don't just do that. We're doing that in every way. So there's a group of men, the African American Coalition at Norfolk Prison, that are very engaged in all this work. Just left them meeting with them last Friday, which was my second meeting with them. The work of conviction integrity, the work of making sure that wrongful convictions don't stand, is vitally important to us and to our office, and important to me personally. The other thing I would say too is that I think we need to be careful about overly politicizing this progressive movement, because movements survive people. Movements survive one political idea or one person or ideology, and here's a person who was removed as a result, who was shaking his head in agreement, right? Progressive prosecution can and will continue regardless of who the people are, because it's the right thing to do. The right thing to do, and that's why it will survive.
Do you see any value, District Attorney Hayden, in having somebody with extensive criminal defense appellate experience either heading in or working in that unit?
I think it's vitally important, and I think it's also vitally important to have people that are willing to be hyper technical and are willing to think outside the box, willing to really dig in and investigate. The job of someone who's doing conviction integrity review is, at least in my mind, significantly more investigatory in nature than being, for example, an appellate attorney. And that's one of the correlations I think that people draw. Oh, appeals, conviction integrity. There's some very distinct differences. And one of those distinct differences is being willing to look under the hood, to be able to look at what's not only what's there, but what's not there and why. And most recent, I'm not going to. It's a case that was mentioned very recently today. And I'm not going to mention it again by name because I don't want to get into issues of confidentiality, but it's a case that started under now U.S. Attorney Rollins, which we continued, and I agreed, and we overturned that conviction because it was a question about what wasn't there, not so much about what was there.
Yeah, Mike.
Yeah, thank you so much. I guess this question is largely for Mr. Boudin, sitting at the left of the table, but happy if anyone wants to chime in. This past summer, I had the opportunity to intern at a public defender office, and the DA in the city where I interned ran as a progressive and, had a lot of progressive policies, but there was an overwhelming sense that the line DAs were not exactly on board. They were digging their heels in, whether it was overcharging or being stingy with pleas. I'm curious, as the kind of chief of the office, how do you deal with dissension in the ranks? How do you reach people who grew up in a very different era of the tough on crime, mass incarceration mentality?
Yeah, it's a tough challenge, and I think there's a lot of different ways to approach it, and some, the strategic thinking is going to depend on the rules on the ground. So just to give you an example, if you're District Attorney Gascon in Los Angeles, your staff have civil service protection, so they can sabotage you as much as they want, and you can't fire them. If you're in Alameda County, they have good cause termination protection, not civil service, but you need to have a reason to fire them. If they're in San Francisco, they are at-will employees. And that's the kind of range of options that you're looking at across the country, depending on the jurisdiction. It makes a really big difference. That being said, I'm not a proponent of, and I didn't take the approach of coming in and firing everybody who I thought might disagree with me. I took the approach of saying, I want to win people's hearts and minds. And let me just explain for a minute why that is. I looked at the staff in my office, and I know you all have professors who've dedicated, people on this panel, people in this room, who've dedicated their lives, their careers to being prosecutors. And maybe they did it using what you might call a traditional approach. Maybe they didn't do it using the progressive prosecutor approach. If you assume that because policies, practices, evidence, data have changed, or because you've come along and you have a different vision for how things should be done, or voters have changed their views, that those people are all disposable, you're making a huge mistake. There's tremendous institutional knowledge and commitment to justice and to safety within the rank and file, even if there's going to be some resistance to the policies you implement. Let me say it a little bit differently. If you come into an office and you tell the people who've been doing that work for 10 years or 20 years or 25 years that they're bad racist people and that they've been causing harm in their community, you're going to engender more resistance than you're going to win support. And so there has to be a way to implement even urgently needed changes that doesn't alienate the people who've dedicated their lives to this work. The people in the district attorney's office in any part of this country who've been there for a long time, it may be that maybe we can all agree, probably we can't all agree, but maybe we can all agree hypothetically that Those policies have contributed to mass incarceration, the destruction of Black and brown communities, the transfer of wealth from poor neighborhoods to wealthy neighborhoods. We can have a system critique, and maybe it's spot on. But the people aren't doing that work because of a desire to achieve those harmful outcomes. They're doing it because they believe they can advance safety and uplift victims of crime and keep communities safe. If they're misguided, or if we have better ideas, we've got to persuade them of that using data, using leadership. And I think there's a role for firing people and for reassignment and for bringing in new energy. But I think it's a small role. I think we've got to respect the limits of our own knowledge and be humble, even as we have the courage of conviction.
Anybody else want to comment on that question?
I would just add that it is one of the reasons we came in as change agents. Rachel came in as a change agent. And that was one of the reasons why the written policy was so, the Rollins memo was so critical to say, not just to the community, but to her staff, this is what I expect of you. And it was tough. It was definitely tough. But she's also a person who's lived paycheck to paycheck. So she felt strongly about not firing anybody. We had people left, voted with their feet by leaving. But we also, we had sort of the reverse of that problem with our first class that we recruited of new ADAs, because they were mission driven, the new ADAs who came in. And it was hard for them to prosecute cases because they really believed in progressive prosecution. And for them, that meant really restorative justice and alternatives to incarceration and alternatives to prosecution. But there are cases when you're in Suffolk County, when you're in any other counties, and there are cases that need to be prosecuted. So walking that fine line of running a mission-driven office, but making sure that you're keeping your community safe is tough work.
Judge Harris.
On VA Hayden. In light of the case in Memphis, where what was called the Scorpion Squad, well, in Boston, they call it the Jump Out Squad. When they have a pretextual stop of an automobile and then search and abuse people in the community, the DA could stop that by not prosecuting those cases. You had any opinion about that? Another part was the sentencing of so many people in our community. I know we talk about conviction overturning, but also sentencing is another part of that.
So there's a number of layers there, and in full disclosure, and I shared this earlier, God bless you, Judge Harris. I judge you, everyone in this room should know, probably the one judge I was in front of more than anyone else during my entire career, because I was a prosecutor in the juvenile unit. Then when I went to do criminal defense work, I wanted to represent juveniles. I found the only way I could do that was to get on the list, because most people aren't retaining a private attorney. And I got on the list since I was in juvenile court as both a defense attorney and as a prosecutor, and probably spent more time in front of you than just about anybody. And thank you for that. You taught me so much. So it's I watched those videos from the weekend probably more times than I would care to, because I felt an obligation to. And so it becomes not just a matter of not prosecuting certain cases that come before you when you know wrongdoing was done, but it also comes down to prosecuting people who do stuff like that. I'm glad that in this particular case, the swift action was taken. It's unspeakable. And so it has to go both ways. And we talked about that a little bit earlier. It's a tough job of a progressive prosecutor that's willing to do justice and do the right thing. It's not just not prosecuting cases where the malfeasance was done, but it's also holding people accountable when they do things like that. And it's easy to, in a case like this, say, oh yeah, we're holding. I'm talking about maybe a much grayer situation than that, where you have to call it out and say, no, that will not stand. We have to be absolutely willing to do both. And to your second question, yes and amen. It's something that I'm continuing to examine and look at, and I'm talking with the people in my office now around conviction integrity. It's not just whether or not a conviction was fair, just and right and proper, or whether something wrongful was done. Sometimes it is just a matter of the number. Sometimes it is just a matter of how long does someone have to be sentenced for. That's what we're looking at right now with the issues involving juveniles, right? Who committed it, you know, by all accounts, horrible offenses, but they did it when they were 18, 19 years old. Do they need to rest of their life? No, they don't. Do people need to be on lifetime parole, no matter what, just based on the offense? Whether they've been rehabilitated, whether they've gotten better, whether maybe they have health conditions that automatically reduce the risk of reoffensive recidivism, but they're still on lifetime parole. We have to look as prosecutors and as judges, as an entire system, at how we sentence people and what's appropriate. And when we need to adjust that when it's appropriate as well. Absolutely.
Donna, go ahead.
So we also, Judge Harris, under the Integrity Review Bureau, had a sentencing integrity pilot. And we try to look at unjust sentences, again, getting applications from defense attorneys and individuals to address those. So, you know, the classic example, a case that I worked on where there were two brothers, one brother pulled the trigger, one brother stood by him, unclear what his intent was. The brother who stood was tried first, convicted of first-degree murder. The second brother was tried, testified in his own defense, convicted, said he was killed that day, was convicted of second-degree murder. He's been out on parole for 12 years. And the brother who stood near him is serving a life sentence. We tried so hard on those cases. Those were the cases that we got the most pushback from the judiciary. And God, you know, I'm an appellate nerd. I've said that already. I will claim that title proudly. And I love the separation of powers. But in Massachusetts, it is very difficult, nearly impossible, for a prosecutor to relook at an unjust sentence unless you can get that judge on board.
I want to just follow up on a couple points. One is, I think it's really important to not let post-conviction relief be reduced just to exonerations for people who are wrongfully convicted for a lot of reasons. That's critical, and it's its own category, but it's a lower standard, a faster process, and a necessary role for progressive prosecutors to look at some really extreme sentences and bring people home if there's not a risk to society. And we exonerated in my 2.5 years just one person. We resentenced more than 75. So, you know, those are two different categories. There's overlap. Maybe the same team works on them. It's a different legal standard. It's a different inquiry. And I think it's really important that we're doing both of those things. I also want to respectfully, Your Honor, push back a little bit on something you said. And I want to do that for two reasons. First, I don't want Mike to think I only push back on him. But second of all, I think it's an important lesson for all the law students in the room, that you will have judges who do things you disagree with or say things you disagree with, or maybe that are simply factually wrong, not that that's the case here. And it's really important that you learn and have the confidence to push back with respect on the court for your clients and for your position and for the record, even if it's uncomfortable to do so. And I've never met Judge Harris. I never had the honor of appearing in his courtroom. He said something really important that I want to follow up on, and I want to disagree a little bit with. He said that district attorneys have the ability to stop pretextual traffic stops. We agree. I'm reading into his comment. We agree that pretextual traffic stops are a major problem. They don't just lead to deaths like Tyree Nichols. They also are responsible for a significant percentage of officer injuries. So it's not only, though critically, about preventing wrongful deaths of mostly young Black men. Yes, that for sure. It's also about officer safety, officer resources. It's about trust between communities that are high crime and often don't cooperate with police, et cetera. But I implemented that policy when I was DA. In fact, it was about a month after taking office during Black History Month, February, which we're in now, Happy Black History Month. They don't celebrate that in Florida anymore, apparently. We implemented a policy, and maybe it was extreme in the way that Mike's mentioned, in the sense that we said we will not prosecute cases that involve contraband that stem from pretextual traffic stop. If there's a stop and the officer gets attacked, well, we're gonna prosecute that. But if they do a pretextual stop and then they search you and they find some dope, we said, we're not gonna prosecute it. And I expected and hoped that it would lead to a dramatic change in police behavior, but I was wrong about that. The statistics out of San Francisco show that African-American drivers continue to be dramatically more likely to be stopped, and if stopped, searched, and if searched, arrested, and if arrested, brought to jail. So much so that our police commission just had a big public fight over that exact issue, because even though I had implemented that policy, which had been on the books for more than 2 years, it was such a big issue that our police commission just had to implement a policy that went further and was more detailed and had more teeth in terms of controlling police behavior than anything ISDA could do. So I'm pushing back respectfully, but I do agree, and I think it's critical that DAs, even if it doesn't change police behavior, take the initiative to not amplify the wrongdoing that's committed upstream from us in that way. Thank you, Your Honor.
Any other questions? Back here.
First, thank you all for joining us, and it's great to hear your words. This question is directed mostly towards Attorney Patalano, but I'd love to hear everyone else's input. In thinking of wrongful convictions, in my own experience at the Boston College Innocence Program, the judiciary is something that I didn't realize was almost a hurdle behind progressive prosecution. And without going into specific cases, you see that even when you have the DAs on board and you're going for a new trial, sometimes the judiciary is so not used to not adversarial system. So I'd like to hear your comments on how you think that can be changed, or how you think that can be confronted in a way that still promotes changing wrong conditions.
Sure. And you know, a shout out to Professor Beckman and Professor Whitmore and the good work that you're all doing in the Innocence Program. I mean, you're doing amazing work. So thank you for that, because there were many times when the BC Innocence Program brought cases to the table, and the ability to dialogue and collaborate on those conviction integrity cases between the defense and the prosecution is critical to getting the right outcome until you become in front of the judge, as you have found. You know, I will say you're typically in front of Superior Court judges. Their job is to apply the law as it exists. Some are not willing, you know, I shouldn't say not willing. They're not the Supreme Judicial Court, you know, and I know that some have felt frustrated about the constraints that they feel by following precedent. Certainly that one case that I just told you about, the brothers, you know, the case was, it was reduced to second degree. So we did have a win. He had been released, but in order to have a parole hearing under the regs, the way that the Secretary of EOPS read it, he had to be incarcerated in order to get a parole hearing. So he had to go back in, even though, I mean, it was just insanity, right? So, and the judge basically, you know, I've had judges with tears in their eyes, like this is all I can do. For the fear maybe of being flipped, you know, I'm not sure. It is about being respectful to the judiciary and then saying, okay, SJC, here we come. And being willing to be bring it to the SJC and still stand up. But we lost it to SJC at times too. I know Dara can tell you of examples when she was in front of the single justice of the SJC and they were calling her on the carpet for a change. The investigation continued. We learned new things. We changed our position. And Dara was called on the carpet by a justice of the SJC about that. That's the kind of bravery that the prosecutor has to show. So it starts with collaboration and maybe it has to end with bravery.
Okay, I'm going to take a question, last question, and I'm going to take it from somebody who's participating remotely. We've talked a little bit about reform from the left. I was wondering if one or more of you wanted to comment on reforms, legislative reforms that we can expect in the next few years coming from the right. And what we should expect and what progressive prosecutors should do to respond.
So yeah, in Massachusetts, I don't think you're going to see much from the right. The Massachusetts is, you know, according to the headlines of the Globe, has a barely functioning Republican Party. You know, the big misunderstanding in Massachusetts is we really are not a democratic state. We're an independent state that votes Democratic a majority of the time, but the elections are all decided by independents. The other thing I'll say is, maybe I shouldn't, but this is maybe
It's
why.
not too late.
This is maybe why I can get elected, but I think this is important to say. In Massachusetts, I'm not a huge fan of the legislature. They do everything behind closed doors, right? They meet in committee behind closed doors. They're not subject to public records. They decide things and you have 24 hours to act on them before they vote on them. Is that the democracy that we want to have? And yet it's, you know, you can point to the state house as being progressive. I don't think it is. I think it's a silo of silence that occasionally gets good work done. In my humble opinion.
All right, well, thank you all for